The Working Group on Aging is called to order. It is my distinct pleasure to extend a warm welcome to our panel on access to justice. I would like to extend a warm welcome to you all. Dear colleagues, it is a pleasure to be able to chair this panel with various experts and to share this debate on a crucial area, which is indeed a crucial relevance: access to justice for older persons. Access to justice is a fundamental principle of the rule of law. All should, in equal conditions, enjoy the equality provided by law and effective access to justice, to just solutions to disputes, significant participation, and to be heard. To be heard. This is, for all of us in this open-ended working group, something that applies. We should listen to each other and try to understand one another, to try to find solutions. The Inter-American Convention on the Protection of Human Rights of Older Persons was ratified by the Republic of Argentina in 2017 and establishes in Article 31 that older persons have a right to be heard with the due guarantees within a reasonable time by a judge or competent tribunal, which is also independent and impartial and established previously by the law. In any criminal accusation made against it, or in order to determine their rights and obligations of a civil, employment, fiscal, or any other nature. It also states that the state's parties commit to ensuring that the older person has effective access to justice on an equal footing with all others. Access to justice is a cross-cutting right which has repercussions in the exercise of all human rights for older people. And this is why I suggest that we hear from our panelists and we have a fruitful exchange on the current and future challenges so as to move towards the full enjoyment of the right to access to justice for all older persons. So I now give the floor to Mr. Craig McIver, Director of the New York office of the High Commissioner for Human Rights, for his presentation in connection with Conference Room Paper A/AC.278/2020/CRP4. Mr. McIver, you have the floor. Thank you very much.
Thank you very much, Madam Chair. Excellency, distinguished delegates, dear colleagues, access to justice is a concept that is come of age. And when meaningful access is extended to older persons everywhere, the age discrimination that plagues our world will be a concept destined for the trash heap of history. But we have a long way to go. The Universal Declaration of Human Rights provides for the right to equality before the law without discrimination, equal protection under the law, the right to an effective remedy for violations of rights, and the right to a fair trial. Respect and protection of human rights can be guaranteed only by the availability of effective judicial remedies. And when a right is violated or a damage caused, access to justice is of fundamental importance to the restoration of the dignity and rights of victims. Indeed, access to justice is both a fundamental right in itself and also essential as a prerequisite for the protection and promotion of all other human rights. Guaranteeing access to justice is indispensable to the functioning of a democratic governance, to the maintenance of the rule of law, and to combating social and economic marginalization. Access to justice secures rights such as the right to health, as it guarantees judicial and administrative protection of that right. Access to justice matters for the Sustainable Development Agenda and its commitment to leave no one behind. The inclusion of Target 16.3 in the SDGs commits all member states to promote the rule of law at the national and international levels and to ensure equal access to justice for all. Yet millions of older persons across the world are facing significant challenges in accessing justice and remedy for their human rights. Submissions received by our office from stakeholders indicate that the majority of older persons have had justice problems across a wide range of issues. This includes disputes over land and property, difficulties in accessing public services, financial and debt problems, family disputes, violence and crime, and problems at work. While most constitutions and national laws guarantee access to justice by everyone and the right to equality before the law without discrimination, very few of them take into account the specific challenges faced by older persons. Physical barriers and lack of accessible buildings and transportation prevent many older persons from accessing the courts and legal aid, especially those living in remote areas. Often, court proceedings are not adapted to older persons' needs and abilities and do not provide reasonable accommodation. Age-based digital divides are creating additional barriers for older persons as applications and documents are increasingly processed electronically. And many older persons simply cannot afford court fees and legal representation. In many countries, courts are overloaded with cases, and legal proceedings can take a very long time. But for older persons, particularly those in the highest age ranges, justice delayed may literally be justice denied. For many persons who are older, cultural norms also further complicate justice, particularly older women's access, with notions of honor and shame sometimes associated with resorting to the legal system to resolve disputes, especially those relating to family matters, inheritance of property, violence and abuse. Distinguished delegates, there are significant gaps in the enjoyment of human rights by older persons that must be addressed urgently. And contributions received from stakeholders indicate that efforts are being taken by states and others to begin to address these challenges, and these reveal several promising practices. Among these, putting in place a network of community justice centers available to support older persons, ensuring new constructions are barrier-free while retrofitting old court buildings, policies and programs providing free legal aid, although most of these are still based on income and are not age-specific. National human rights institutions are providing individual assistance, awareness raising, effective monitoring, and enforcement of equality law. And civil society organizations are promoting awareness, capacity building, and legal and social and psychological support. And yet, the responses also demonstrate that overall, most guarantees of access to justice are of general application, and essential elements of the right to access to justice remain ill-defined, too general, and not adequately targeted to the particular challenges faced by older persons. Where laws and policies at the national and regional levels do not recognize older persons' access to justice, and standards and applications are inconsistent, and practical implementation is often lacking. Furthermore, many have pointed out that entrenched ageism exists within the justice system itself, and that laws and policies themselves can be ageist. All human beings are born free and equal in dignity and rights, and our rights do not expire or diminish with age. If rights are to be given the force of law, no one must be denied access to justice on the basis of their age. Guaranteeing access to justice is indispensable to combating inequality and exclusion. But international standards lag, and national practices remain cause for worry. As a universal right, access to justice needs well-defined international standards and clearly articulated obligations of states to guide its effective implementation and enforcement. Almost 3/4 of a century after the adoption of the Universal Declaration of Human Rights, a majority of older persons are still seeking justice. It falls to all of us to ensure that justice. I thank you.
Muchas gracias.
Thank you very much, Mr. Makaiba. I thank you for your presentation. Following that presentation, we will now proceed with an interactive panel discussion. This will be moderated by Ms. Karen Gomez-Dumpit, Commissioner of the Philippines Commission on Human Rights. The panelists who are joining us this afternoon are Mr. Alejandro Robino, Care Policies Manager and Secretary for Human Rights, Community Gerontology, Gender and Care Policies of the National Institute of Social Services for Retired Persons and Pensioners of Argentina, Mr. Bill Mitchell, lawyer and member of the Community Legal Centres in Australia, Mr. Anthony Ojuku, Executive Secretary of the National Human Rights Commission in Nigeria, and Mr. Zadislav Kedzia, Professor of Constitutional Law and Human Rights at the Faculty of Law and Administration at Adam Mickiewicz University of Poznan and the High School of Banking in Wrocław in Poland. I would now like to invite the moderator and panelists to commence the panel discussion. I give the floor to the moderator.
Thank you very much, Madam Chair. Before proceeding further, I would like to inform the working group about the organizational arrangements for this meeting. This informal meeting is held using remote simultaneous interpretation. I kindly ask participants to be mindful of the additional difficulties experienced by interpreters when working remotely and of the increased likelihood of disruptions to the audio feed to the interpreters. Participants may select the preferred language to hear the interpretation or choose the none option to hear the original language. Participants will not be able to unmute their microphones or engage their video unless given the floor. When called upon to speak, the participant will receive a message saying that their streaming is approved. Please press the video button appearing in that message in order to share your video and audio. If you face audio or video issues during the meeting, please use the Restart All Lines button above the hand icon. Should the problem persist, please reload your browser. I now open the floor for interventions. Let me call on Senor Rubino. You may now have the floor.
Hola, buenas tardes. ¿Me escucha bien?
Good afternoon, can you hear me? Good afternoon, and thank you very much, Chair. Thank you, Moderator. It's an honour for me to be able to participate in this session of the Open-Ended Working Group on Ageing. It's a pleasure to share this panel on access to justice. At the outset, I should like to say that Argentina has a health system with universal coverage, where as well as the services provided by the public sector, we have the social security sector, services provided through social work. This is within our National Institute of Social Services for Retired Persons. And it is the biggest social entity in Latin America with around 5 million members. 90% of them, over 90% of them, are older persons. The Institute has been developing various measures to guarantee the promotion and protection of human rights of its older members. In this regard, I wish to state that the Institute has created a specific secretariat of human rights, community gerontology, gender and care policies. The COVID-19 pandemic has been an extraordinary challenge for the world in terms of access to rights, and this situation is exacerbated if we're talking about those who are 60 and over. In this regard, it's worth underscoring that that Argentina has given the greatest priority to older persons during the pandemic. The independent experts' report on human rights for older persons looked at the repercussions of the coronavirus. The experts said that the COVID-19 pandemic has shed light on the issues and problems of human rights for older persons across the world. Likewise, the Secretary-General called the attention to the indescribable fear and suffering that the pandemic has caused for older persons, and warned about cases of lack of care or mistreatment in some institutions. Again, as a general increase in discrimination by age, which causes trauma and stigmatization. In this regard, it is necessary to have sufficient strategies, effective instruments, which allow us to guarantee the rights of older persons, including dignified access to justice. The human right of an access to justice is a fundamental right, per se, a cross-cutting right, an essential prior requirement for the protection and promotion of all the other human rights. Without access to justice, older persons cannot have their voices heard, exercise their rights, or address discrimination. However, The recognition of this right goes beyond simple due process and effective compensation. Greater visibility and awareness about the society on the rights of older persons is required. We must work on getting rid of barriers to access to justice, promoting specific training for judges, lawyers in general, and everybody who's working in the system of judicial administration, as a collective commitment to guarantee dignified and effective access to justice for older persons. The concept of access to justice has changed over time in various international and regional human rights frameworks. It is in the Universal Declaration of Human Rights, in the International Compact on Civil and Political Rights, and the International Compact on Economic, Social and Cultural Rights. The International Convention on the Rights of Persons with Disabilities was also the first instrument with an explicit right to access to justice. All of these international instruments apply to older persons, of course, as well. However, none of the international instruments on human rights have specifically addressed the barriers faced by older persons to improve their access to justice, such as delays in judicial procedures, physical barriers which hamper adequate accessibility to judicial headquarters, geographical barriers, attitude barriers, discrimination due to age, and so on. It is crucial to work on awareness raising, training, accessibility, availability, and effective resources to resolve these problems. The fact that age does not appear as a clear reason for discrimination in the various instruments I've mentioned is a loophole in the international framework on human rights. This means that many national laws do not address discrimination for reasons of age in an integral way. During the pandemic, ageist attitudes have been seen in verbal attacks, negative images of older peoples in the media, and in public debates across the world. The United Nations principles in favour of older persons are insufficient in the light of the pandemic we've been through. In this regard, the International Action Plan from Madrid on Ageing does not contain any specific commitment to strengthen access to justice for older people, except a few references in the context of violence and abuse against older women, where they lack access to legal protection. In any case, this is not a binding instrument. At regional level, we have the European Charter of Fundamental Rights, however, which does stipulate equality in law for older persons, including the prohibition of discrimination against them. We also have the African Charter and Protocol of Human Rights of Peoples, which does specifically recognise the access of older persons to justice and equality of protection before law for them. In my country, Argentina, access to justice, as I explained at the beginning, is enshrined in Article 31 of our convention. And Article 2 explains what discrimination is, and recognition in law it can be found in Article 30 of the convention as well. We have Law 27360 ratified by the Inter-American Convention, which makes the region into the first in the world to have a binding instrument with specific protections to defend the human rights of older persons. The adoption of this treaty is a true step forward in terms of our paradigm around ageing and older persons, and means that older persons truly are rights holders. Article 31 of our convention guarantees that the older person have rights to be heard with the due guarantees and within a reasonable amount of time. To make this guarantee effective, the Convention requires states parties to adjust changes in procedure, giving preferential treatment to older persons for the resolution and implementation of decisions during any judicial administrative processes. As well as this preference at all stages of the process, states oblige judicial proceedings to be particularly expeditious and swift in cases where the risks, the person's life or health are at risk. Finally, states parties must develop and strengthen public policies and programs aimed at capacity building for all those linked to judicial administration on the protection of older persons. This includes also police and penitentiary staff. It is important to say that the pandemic has shed light and laid bare the lack of access of older persons to many rights, which is why international legal frameworks must be improved. The lack of an international legal instrument which is broad and integrated to promote and protect the rights and dignity of older persons still has important practical repercussions, particularly for older persons in emergency situations. The COVID-19 pandemic is an enormous challenge for societies across the world, but it is also an opportunity to generate an international instrument which allows us to strengthen the rights of older persons. This crisis must become a watershed moment, a crossroads for all states. An international convention will provide an effective tool to guarantee access to rights for older persons, but also to combat age discrimination and to make it sustainable to build a society for all ages, with nobody being left behind. Thank you very much.
Sí, está moderado.
Thank you, Madam Moderator.
Thank you very much, Senor Robino, and we appreciate the fact that you actually described access to justice as going beyond due process and looking at the positive and, of course, negative obligations that come out of access to justice as a state responsibility. We now move on to Bill Mitchell of Australia. You have the floor.
Thank you. Let's share my screen. Can that be seen okay, moderator?
I still cannot see your presentation.
Let me share my screen. Let's try it now.
There, it's booting.
Okay.
All right.
Thank you, moderator, and thank you, Chair, for this invitation to take part in this panel. Can I first acknowledge that I'm on the country of the Wulgurukaba and Bindal peoples here in Australia, and I pay my respects to their elders past and present. Can I first talk through an overview of the issues? In this case, older persons are within a justice gap. They're people for whom a justice gap still exists. The absence of a dedicated international normative instrument significantly limits their access to justice. United Nations human rights treaty bodies and thematic special procedures have not and cannot address older persons' access to justice in meaningful or methodical ways. And despite 30 years, the UN principles for older persons still provide only limited recognition of access to justice, and they're not binding. The COVID-19 pandemic has had an unprecedented effect on the functioning of justice systems and older persons' access to justice at a time when it was most critical to their lives. The UN Development Agenda is not assisted. The Sustainable Development Goals at 16 lack specificity for older persons, and the Madrid International Plan of Action on Ageing only recognises access to justice within a very narrow focus, that is the lack of legal protection for violence against protection from violence and abuse. Ageism still remains the major factor, and it's a central framing issue for access to justice for older persons. And like the UN principles, age friendliness is also dependent on access to justice. In the absence of normative protections and obligations, older persons' legal needs have not been systematically assessed and data has not been collected. They essentially remain invisible. So how big is the justice gap for older persons? The World Justice Project's data estimates that something like 637 million older persons face a justice gap. That includes 187 million who cannot access civil, administrative or criminal justice, and 562 million who are excluded from the opportunities that the law provides. Well, why does this matter? Because access to justice is a fundamentally important freestanding right, because it protects and promotes other human rights, because justice problems negatively impact on older persons' lives, and older persons lack legal identity and suffer further exclusion. And how does this justice gap actually manifest? Well, mostly through institutional and personal barriers. There are very few specialist services for older persons. They have restricted access to legal aid, And this combines with limited knowledge and information about where to actually find help. They end up relying on family and friends. They're excluded by digital platforms, including social media and law online. They may have limited access to funds, including because of the impacts of elder financial abuse or economic disadvantage. There is a perception and a reality that the law is disempowering and inaccessible. There is also a belief that the potential benefits of engaging in the legal system are outweighed by the stress, cost, and delay. There is a lack of support, aids, and adjustments to accommodate age-related needs, and psychological barriers such as disempowerment, diminished self-confidence, and feelings of shame and embarrassment are also major barriers. So we find ourselves with ageism within the justice gap. And without normative controls, ageism still sits right at the centre of this justice gap. Ageism is prevalent, it's deeply ingrained, and it's more socially accepted than other forms of bias. The determinants of older persons' failure to access justice include a mixture of institutional, systemic, interpersonal, and self-directed ageism. Institutional ageism is widespread. It impacts on all aspects of the legal and justice system, in courts, in law enforcement, in legal assistance, dispute resolution, and the legal profession. Systemic ageism is pervasive, and it also affects older persons both directly as participants, such as litigants and complainants, and also indirectly, such as witnesses and jurors. And self-directed ageism is a common barrier as well, and this is reinforced by interpersonally and institutionally based forms of ageism. Ageism also includes arbitrary age limits that both necessitate and limit older persons' access to justice. So without normative standards, the legal and justice systems are hopelessly contaminated by ageism. Older persons are seen as having a lower compensatory damages value, as less credible witnesses, as less able or impartial jurors, as less needy of legal assistance, a lower priority for law enforcement, and protective legal processes. These are all stereotypes. The consequences include lost autonomy and independence, violations of their rights to family and privacy, health services, freedom from violence and abuse, and institutional neglect. This is clearly discrimination. The results include very low numbers of older complainants and litigants, and legal processes are less commonly commenced and even finalised. Older persons have less successful outcomes or simply fail to obtain the opportunities that the law can provide, and this is prejudice. And so without normative expectations, legal settings and processes remain entrenched with ageism. We have decision-making guardianship regimes which erode self-determination. They also erode privacy, autonomy, independence, and dignity. If they exist, anti-discrimination laws often forgive common areas of age discrimination. We have care facilities that confine, control, and dehumanise older persons without access to review. We have detention facilities that are ill-adjusted to older persons' needs and their rights. We have legal and court processes that alienate older persons. We have criminal laws and prosecutorial conduct that ignore and negatively construct and downgrade older persons' inherent value and their need for protection. Again, these are all manifestations of ageism, of stereotypes, of prejudice, of discrimination, and even hatred. So what we have is a paradox. Why don't we have a specific guarantee of access to justice for older persons when ageism is more pervasive than sexism and racism? 1 in 2 persons hold ageist attitudes. When ageism interacts with other forms of bias such as sexism, ableism, racism, homophobia, heterosexism, and exacerbates older persons' disadvantage. When abuse is estimated at 1 in 6 across all settings, including community and institutions. When age friendliness is obviously undermined by the absence of justice, including limited accessibility, both physical and affordability, limited availability, and the absence of reasonable accommodations. And when almost half of self-represented litigants are 50 years or older. Combating ageism is the principal reason why older persons need access to justice rights, and yet, without a normative standard, structural ageism removes their opportunity to participate in justice on all levels. So we find ourselves with a very important intersectionality issue. Older persons' need to access justice is heightened by many other factors, including their gender, their Indigenous status, their race, socioeconomic status, health, geographic and social isolation, their living and care arrangements, their incarceration or their detention. But despite this increased need, access to justice is more restricted for older persons with these intersecting factors. And so for older persons, the greater their need for justice, the less chance that it will be attained. There's an example of intersectionality given in the World Health Organization's Ageism Report. The Secretary-General's suggested solution to COVID-19's impact on older persons' human rights is for a strengthened international legal framework. We need to accept that the absence of a clear and enforceable right to access to justice has meant and continues to mean that ageism, age discrimination, hate speech and stigma will continue unabated, as will the impacts of those things on older persons. Violence, abuse and neglect will remain hidden without law enforcement and judicial oversight. Healthcare is not provided on an equal basis and will remain discriminatory. Emergency situations will mean the right to life is in peril. Detention and confinement will remain without proper accountability, monitoring or review. If I can briefly touch on the Australian context, even in a place like Australia with a strong rule of law, older persons still don't have equity of access or necessary recognition. Examples include court equal treatment benchbooks don't include older age. Access to formal legal aid is very poor, in fact below 1% of all grants of legal aid. Older complainants under federal anti-discrimination laws are the lowest of all groups, 3%. We have no specific criminal laws against elder abuse, and half of all long-term care residents experience restrictive practices without effective regulation or redress. We recognise that specialist programs do make a difference, but of course, they themselves will also benefit from normative guidance and better resourcing. If I can give one good example of the intersectionality within the Australian context, older Indigenous persons who have specific access to justice needs. The factors included and recognised are historic, cultural and trauma-related issues such as historical abuses, stolen wages, institutionalisation and of course, importantly, the impacts of colonisation. Indigenous persons' lived experience reflects the intersection of ageism, racism, often gender and ableism, compounded by their remoteness and compounded again by linguistic and cultural issues. The factor and importance of kinship care models and the need to honour and support their role as community elders and leaders of self-determination also bring to bear considerable access to justice issues. To this end, two of Australia's peak bodies, Community Legal Centres Australia and the Law Council of Australia, which represents some 60,000 lawyers, have called for drafting to begin on a Convention on the Rights of Older Persons. They have echoed the Secretary-General's call for a stronger legal framework at the international level to protect the human rights of older persons in emergency settings such as the pandemic and also in everyday settings. I thank the Chair.
Thank you very much, Bill. In your presentation, I'd like to just underscore the fact that you've located older persons within the justice gap, and a fragmented response cannot be, cannot address this justice gap for older persons. And the fact remains that there is also self-directed ageism, and that calls for governments, states to be able to create that enabling environment so that older persons themselves are aware of their rights and can demand and be empowered about their rights. Thank you very much. We now move on to Anthony Ojuku of Nigeria. Sir, you have the floor.
The chairperson and the moderator, I'm happy to be here to share our perspectives on access to justice. Now, access to justice is defined as the ability of people to seek and obtain remedy through formal or informal institutions of justice for grievances in compliance with human rights standards. It's also more than an individual's access to courts or guaranteeing legal protection or representation. Access to justice is a basic principle of rule of law and human rights. In the absence of access to justice, people are unable to have their voice heard, to exercise their rights, to challenge discrimination, or hold decision makers accountable. Access to justice also affects the right to autonomy, independence, and long-term care for old persons. Rights of older persons that need protection and that may affect their access to justice include the right against discrimination, the right to social security, the the right to health, the right to work, and the right to property and inheritance rights. Now, there are some factors which inhibit access to justice for older persons, and this includes the non-enforceability of economic, social, and cultural rights in some countries. Also, the high cost of hiring lawyers discourages older persons to access their rights, and lack of faith in the judiciary, social reservations in some societies, and the tedious time wasting and in the nature of legal process can discourage older persons from embracing the legal process for their grievances. Of course, at times there are no support from their families, the weak financial status, and inadequate legal framework for the protection of older persons, both at the international and national level. Lack of access to information by older persons as their rights and how to access them. Ageism, which is the prejudice, bias, stereotyping, and discrimination against people on basis of their age. The lack of social security, which for coverage for older persons, and illiteracy, which is predominant in the older population. And of course, poverty and lack of national policy for the protection of the rights of older persons. There are some common access to justice mechanisms across all the countries, which include the law courts, the National Human Rights Institution, the National Pension Commission, for instance, the Legal Aid Council in some countries, social welfare centers, Public Complaints Commission or the Ombudsman, the Ministry of Justice, Pension Transitional Arrangement Directorate, Senior Citizen Centers, and community-based grievance redress mechanisms. There are legal frameworks for access to justice for older persons. At the national level, the legal frameworks are weak for the protection of the rights of older persons. For instance, in Nigeria, the right for protection of older persons is enshrined in Chapter 2 of the Constitution of the Federal Republic of Nigeria, where you have directive principles of state policy. And these are said to be non-justiciable. The Pension Reform Act is contributory. Therefore, it excludes the informal sector and, of course, peasant farmers, and this affects their social protection clause, and they now depend on their families. At the regional level, you have the African Charter on Human and People's Rights, which makes provision for the protection of rights of older persons. In Article 18.4, it provides that the aged and disabled shall also have the right to special measures of protection in keeping with their physical or moral needs. It also provides that they are supposed to respect for his parents at all times to maintain them in case of need. At the international level, you have the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights and other international instruments. But the fact about this Bill of Rights is that they provide for the principle of equality and non-discrimination on account of race, religion, sex, gender, and nationality, but fail to specifically prohibit discrimination on account of age. So unlike Article 1.1 of the International Convention on the Protection of Rights of all migrant workers and members of their families, where age is included as one of the grounds under which there should be non-discrimination against migrants and their families. Apart from the International Convention on Protection of Rights of Migrants and Workers and members of their families, other international human rights instruments contain normative gaps on rights of older persons. Accordingly, the neglect of the rights of older persons at the international level is further compounded by the fact that while other categories of persons stand as vulnerable, such as children, women, persons with disabilities, all have specific human rights instruments addressing their rights and peculiarities, there was none specifically dealing with the rights of old persons, despite their unique vulnerability. What we are left with at the international level are soft instruments, such as the Madrid International Plan of Action on Aging, 2002, the UN Plan of Action on Aging, 1982, the UN Principles for Older Persons of 1991, and the UN Proclamation on Aging of 1992. These soft instruments are not legally binding and therefore only propose a moral obligation on governments to implement them. It is for this reason that there has been a sustained clamor for a UN convention to protect the rights of older persons. The National Human Rights Commission of Nigeria therefore fully supports the 11th open-ended working group on aging that it proposes a draft international legal instrument for the protection of the rights of older persons, and this will help national human rights institutions better help older persons to access their rights. In conclusion, the soft instruments prescribing normative standards on the rights of older persons are not legally binding and therefore only impose a moral obligation on the government to implement them. It is for this reason that there has been a sustained clamor for the UN Convention on the Rights of Older Persons that would bind government and better protect the rights of older persons. There is need to strengthen the legal framework for the protection of rights of older persons, and stakeholders should collaborate to develop mechanisms and advocacy plans for the ratification and domestication of the protocol, the African Charter on Human and People's Rights on the Rights of Older Persons in Africa. The National Human Rights Institution should be strengthened and empowered to adequately develop in-house policies and strategic plans of action to specifically address the issue of access to justice for older persons in order to enhance redress mechanisms for violation of their rights while awaiting a binding international document. The situation of older persons requires urgent attention by all stakeholders. This is evident with the projection that the aging population shall surpass the population of young people between the ages of 1 to 15 years by 2050. The 230 SDGs, which seek to promote the principles of equality, non-discrimination, and inclusion, provide us with an opportunity to begin to tinker with how we can raise awareness on the plight of older persons and the human rights implications of ageism. It also provides an opportunity to articulate legislation and policies that will care and protect the rights of older persons in order to integrate them in the future development plan. I want to thank you, Chairperson and Mr. Moderator. Thank you for listening to me.
Thank you very much, Tony. Just to stress, of course, from your presentation that, well, access to justice is not just on laws and process, but also in terms of infrastructure, and you've named the judicial and non-judicial mechanisms that are available in your country. Thank you very much. And now we proceed to the last panel speaker, Mr. or Professor Kedzia. You'll now have the floor.
Thank you very much, Madam Moderator, Madam Chairperson. In my intervention, I would like to focus on the area of economic, social, cultural rights, and specifically on 2 points. The general relation between access to justice and economic, social, cultural rights of older people. Access to justice, the second point, by older people under the International Covenant on Economic, Social, Cultural Rights. I must say that this is an area which is very close to my heart since I spent several years in the Committee on Economic, Social, Cultural Rights. No doubt that the rights relevant to physical and mental well-being, including the right to work, social security, health, housing, etc., are essential for older persons' life in dignity. Equally important are rights that enable older people to partake in social life and acquire capabilities necessary for self-determination and self-realization, including the rights to participate in culture, scientific and technical progress, and continuing education. And I wanted to stress that I'm talking here about human rights. It means legal entitlements and related obligations, and not about charity, which sometimes overlaps. The discussions on charity overlap with the discussion on rights. Of course, charity is also, under some circumstances, indispensable. The enjoyment of these rights is often subject to procedures determining the type and scope of services provided by obligated public institutions or private entities. This process as we all know, has a great potential to generate disputes between rights holders and responsible actors. Access to justice means, in this context, the legal framework for individuals and groups to effectively claim their rights, the pursue quality of services and seek protection against rights violations. As we know, disputes around the justiciability and enforceability of economic, social, cultural rights have a long history. But remarkably enough, already in 1978, Capelletti and Garth, in their landmark project on access to justice, linked the emergence of this doctrine with the rise of social rights. And I think this linkage continues to exist. Today, it is a widely accepted position that economic, social, cultural rights are vindicable, but the applicability of this feature to older people has yet to be fully recognized, specified, and internalized. As the excellent conference paper indicates, the International Covenant on Economic, Social, Cultural Rights basically does not reference older persons' rights. Yet since the General Common Number 6, adoption of the General Common Number 6 on the economic, social, and cultural rights of older persons a quarter of a century ago, the Committee on Social, Economic, Cultural Rights has placed the situation of older people in the center of its interests. There are plenty of references to this group, also in other general comments. From 2008 to 2020, in the framework of reporting procedure, the committee issued about 100 observations and recommendations concerning older persons addressed to 46 states. Although the committee has not yet offered a specific interpretation of access to justice by older persons under the Covenant, its views on social rights guarantees are fully applicable to this group and provide helpful guidance. Since social rights are often, before turning to the selected rules that can be derived from these interpretations, let me make still a general observation. Since social rights are often implemented within the administrative procedure, the committee points out that administrative remedies are vital and must be accessible, affordable, timely, and effective. To satisfy the Covenant requirements, however, such decisions should be subject to independent judicial review. In general, judicial remedies are necessary whenever a Covenant right cannot be made otherwise fully effective. Now, let me refer in the bullet points to some specific rules interpreted by the committee from the Covenant that seem to be particularly relevant to older people. They also address several age-specific barriers in accessing justice. State parties are obliged to inform individuals and groups of their rights and the relevant remedies. That's first rule. Remedies should be available, put in place, accessible in physical and functional terms, and affordable. Relevant procedures should not be unduly complicated or entail unreasonable time limits or unwarranted delays. Older people should have easy access to free legal assistance if they are unable to finance it. The relevant authorities should undertake to prevent violations of economic, social, cultural rights, including through in-advance impact assessment, identifying and addressing the root causes of older persons' abuse, the monitoring of care facilities and strengthening the reporting system, disclosure of relevant information, and legal remedies. States should take determined action in response to economic, social, cultural rights violations by investigating alleged cases, holding perpetrators accountable, and ensuring adequate remedies to victims, including reparation, restitution, compensation, satisfaction, or guarantees of non-repetition as appropriate. Access to justice requires specialized training on economic, social, cultural rights of older persons for judges, lawyers, and public officials, including law enforcement entities. States parties should protect and facilitate the work of human rights defenders and other civil society members who are engaged in assisting older people in ascertaining their rights. And I would like to add one point which is also very important from the perspective of access to justice, because the committee relentlessly encourages state parties to the covenant to ratify the optional protocol to the covenant to open access to justice at the international level for those who claim their economic, social, and cultural rights. Let me finish my short intervention with 2 points. The committee has provided interpretations on many aspects of access to justice under the covenant that can be applied to older persons and offer guidance to states and other stakeholders. Nevertheless, a more systematic and consolidated interpretation focusing on older persons could be helpful. Perhaps an update of General Comment number 6 might be considered for this purpose. And the second remark, it would be crucial that the drafting process of the proposed Convention on the Rights of Older Persons specifically addresses the relevant aspects of economic, social, cultural rights protection, including access to justice by older persons claiming or defending their rights. The expertise of the committee could not only be helpful, but even indispensable in this regard. Thank you very much for your attention.
Thank you very much, Professor Kedzia. Thank you for highlighting the jurisprudence of the Committee on Economic, Social, and Cultural Rights, and also underscoring the obligations of duty bearers when it comes to access to justice of older persons. Now we proceed to the interactive discussion. And I now open the floor for comments and questions to the panelists. I encourage you to keep your intervention short and focused and to refrain from reading prepared statements. The time limits are 3 minutes for national statements and 5 minutes for the statements on behalf of the group of states. The same time limit of 3 minutes applies to statements by national human rights institutions and non-government organizations. Participants wishing to take the floor are requested to click the link to the inscription form, and the Secretariat will now post the link in the chat box. I would like to remind delegations that they will not be able to unmute their microphones or engage their video unless given the floor. When called upon to speak, the participant will receive a message saying that their streaming is approved. Please press the video button appearing in that message in order to share your video and audio. Should you experience any technical difficulties when sharing your video and audio, a technical focal point will reach out to you. Now I give the floor to the representative of the United Kingdom. Sir, you have the floor.
Thank you, Chair. The United Kingdom would like to thank all panelists for their insights. We welcome the opportunity to engage on this important issue. We would like to build on our written submissions by sharing some of our own domestic practices. Chair, in the UK, all persons are able to access human rights protections. The Human Rights Act provides opportunities for all, including older persons, to complain and seek redress for the denial of rights. Further, the Equality Act and similar provisions in the devolved nations includes age as a protected characteristic, making it unlawful to discriminate against older people. There is a range of organizations in the UK that work to ensure that older people are able to access judicial and non-judicial dispute settlement mechanisms. The Equality Advisory and Support Service provides bespoke support to older persons on the issue of discrimination. The Advisory, Conciliation, and Arbitration Service provides impartial advice to employees and employers. Law centers and citizens advice bureaus provide free independent advice to people on their rights and responsibilities. We have worked to ensure that our justice system is accessible for all older persons through reforms to digital services, improved paper channels, and support for users over the phone via web chat or face-to-face. Those reforms recognize that some people will prefer not to use digital services, so we'll ensure that our paper channels are also always accessible. We recognize that in common with other countries and for all age groups, older persons can be reluctant to access the justice system and seek a remedy. Often this is caused by the concerns that the process may be stressful and or entail financial commitment. We therefore endeavor to signpost sources of support as widely as possible, including in doctors' surgeries, in job centers, and on government websites. When the justice system is accessed, there is clear guidance in place for the judiciary and others to ensure that the risk of discrimination is minimized. Chair, we would welcome the panel's views on how governments can work with civil society and others to ensure that older persons are properly able to access the justice system, particularly in the context of the challenges posed by the COVID-19 pandemic. Thank you.
Thank you very much. We now proceed to the second speaker, the National Human Rights Commission of India. Sir, you have the floor.
Thank you, Madam Chairperson and moderator. Thank you for giving me opportunity to make submission on behalf of NHRC India. Madam Chairperson, the older persons population in India is around 135 million now, and that is 10% of the total population, and their percentage share will double in next 30 years. The access to justice is a fundamental right guaranteed to every citizen of the country under the Indian Constitution. For special protection of the older person's right of access to justice, the Government of India enacted the Maintenance and Welfare of Parents and Senior Citizens Act 2007. It obliges children and relatives to look after the welfare of senior citizens, that is old persons. In case of violations of the obligation, such as abandonment or negligence, the Act provides a speedy procedure to claim monthly maintenance for parents and senior citizens and revocation of transfer of property rights by the senior citizens. Under the Act, the tribunals are constituted to receive complaints from parents seeking maintenance from their children. These tribunals, having the power of a civil court, act as the grievance redressal mechanism for the older persons. To ensure that justice is not denied to any citizen by reason of economic or other disabilities, the Article 39A of the Indian Constitution provides for free legal aid by suitable legislation or schemes. Accordingly, the Government of India enacted the Legal Services Authorities Act 1987, which provides for free legal services to the weaker sections of the society. Under this act, a hierarchy of legal services institutions have been created from the national level down to sub-district level in the states. In addition, the Supreme Court and the High Courts have their own legal services committees to guarantee legal assistance to the senior citizens. The Government of India has launched NALSA, that is Legal Services to Senior Citizens Scheme 2016, to strengthen the provisions of legal aid for older persons. The scheme envisages setting up of legal service clinics at every tribunal and old age homes. It also envisages yearly awareness programs to create awareness and to cultivate a culture which is sensitive to rights and needs of older persons. Further, orientation and training programs for lawyers and stakeholders such as government functionaries, police personnel, NGOs, etc., is also envisioned. Some of the good practices in India, as noted by UNDP in its International Conference on Equitable Access to Justice held in 2012, is the Bar Council of India's Standards of Legal Education and Recognition of Degrees in Law, which makes it mandatory for all law colleges in the country to establish and run a legal and clinic under the supervision of a senior faculty member. Pursuant to this, several law colleges in India are actively engaged in providing effective legal aid to the needy across the country. Best practices on providing legal aid include organizing literacy camps, street plays, consumer clinics, and public mediation, providing paralegal services, visiting jails to assist under trials, filing public interest litigation, and creating linkages with NGOs, legal aid authorities, and other government authorities. The National Human Rights Commission India has the mandate to inquire into the complaints, either suo motu or on a petition filed by a victim or any person on his behalf in case of violation of human rights or abatement thereof or negligence by a public servant in prevention of such violation. The Commission has also issued an advisory in the context of COVID-19 on 5th November 2020 to the Union and state governments for protection of rights of older persons in this difficult time of pandemic. Thank you. Thank you, Chairperson.
Thank you very much. Indeed, national human rights institutions are what you call an institution of remedy as well, and thus facilitate access to justice and brings closer older persons to government. Next in line is Age Platform Europe. Nana, you have the floor.
Hi, thanks so much for giving me the floor. Thanks to all the panelists for the very useful insights that they have provided to this panel discussion. I want to focus on the statement on law, or the absence of law as a barrier to access justice. At EU level, for example, the lack of legal prohibition of age discrimination beyond the field of employment means that in many countries it is impossible to challenge decisions that deny older people, for instance, access to insurance or to a loan. That might be particularly important for them to access housing or to travel or to have adequate access to health services, for instance. Additionally, sometimes there are ageist provisions within the law. For example, whereas under the UNCRPD institutionalization is prohibited, international norms, including MIPA, the general comments, merely allow older persons to live at home for as long as possible. This is a language that is reiterated in policy instruments, regional instruments, etc. Now, given this caveat, it is more difficult for older persons to access justice in cases of forced placement, of coercion, or breaches of their autonomy. Judgments reproduce these biases that are embedded in law. For example, in the paper that we submitted for this session, we demonstrate that because more exemptions and justifications apply to age discrimination in the EU Employment Directive, national and EU courts tend to consider age discrimination as less severe compared to other grounds of discrimination, and they continuously reflect biases about the ability of older people to work, and therefore create also further barriers to older people's work. Now, ageist norms also inform and become the basis for the education of legal professionals, and therefore it can be extremely hard to avoid prejudicial assumptions in case law, prosecution policies, and investigation. You can see where I'm getting there here. It's very much a vicious circle. Moreover, and what I want to focus today is that these bias standards impact the ability of older persons and their representative organizations to claim rights and to seek justice. I have conducted research in Ireland, France, and Greece, which showed that older self-advocates and the organizations that represent them lack the capacity, lack the language, the awareness, the consciousness to link individual experiences, but also structural issues like lack of funding or age limits with human rights breaches. One participant in my study mentioned the fact that you put age limits in law sends a signal to the rest of society. And I think that is the cultural signals that then makes a lady in the nursing home thinks that she has to remain in the institution despite her will. Ageism in law also reduces the likelihood that others will stand up for the human rights of older persons, since issues like losing your job, being coerced, being financially or emotionally abused when you're older are not necessarily understood as breaches or are not perceived as equally important. There is research showing that social workers are much less likely to report abuse against older than younger women, for instance. Now, my question is to Mr. Bill Mitchell. What do you think is the potential of a new UN convention to create space for rights holders to participate and demand their rights? How will self-advocates be able to use the UN system more broadly and to improve access to effective and enforceable remedies when they experience discrimination and other rights violations at the national level? Thank you for your attention.
Thank you very much, Nena. At this point, perhaps I can ask Bill to respond to that question, and then we go back to the first question that was posed for the other panelists. Bill, would you like to answer that question of Age Platform Europe?
Yes, thank you. It's an excellent question. It shows how deeply interconnected these rights are and the role of access to justice to protect and promote other rights, such as the right to equality and non-discrimination. I think first, a convention would provide individual guidance for nations about complaints and remedy. So it would give nations a set of standards they'd have to apply in terms of complaints and remedy. It would also include the ability of older persons to make complaints and the sorts of assistance and accommodations they might need. I think it might also give some normative description about what's expected of access to justice when dealing with older persons, including some of their specific needs and interests. It might also provide guidance to member states around how their national institutions of justice will deal with older persons, including courts and tribunals. The sorts of policies that make courts and tribunals more age-friendly. It would also probably indicate that data collection was an important part of access to justice, and so we'd begin to get a deeper understanding of what older people's legal needs are, and that would then give us, at least nations, an opportunity to understand at a national level what legal needs might arise. And in some cases, a convention might give an opportunity for an individual complaint, if it couldn't be resolved at a national level, to a specific treaty body, such as a Committee on the Rights of Older Persons, and to have that matter looked at if that right existed under the convention.
Thank you very much, Bill. We go to the other question that was posed earlier. Perhaps one panelist can answer this, and perhaps Tony can answer this. Your views on how government can work with civil society in the context of COVID-19. Being a national human rights institution, I suppose that you'd be able to answer that very well. Tony? I think we lost Tony. So perhaps we can ask Senor Robino, would you like to answer that question? Okay. Perhaps while, okay, there you go.
Hola.
Hello? Can you hear me? Could you please repeat the question? I had a problem with my internet connection. I'm sorry.
Okay, go ahead.
Could you please repeat the question?
¿Se escucha? No lo puedo.
Can you hear me? I can't hear.
Don't hear the English translation, I'm sorry.
Can the English interpretation be heard?
Perhaps we can move on to the list of speakers, and we'll go back to Mr. Robino. I now call on the United States representative. Ma'am, you have the floor.
Thank you very much, Madam Chair. I'd like to speak a bit about our national legal framework. Modeled after the Civil Rights Act of 1964, the Age Discrimination Act of 1975 prohibits discrimination on the basis of age in programs and activities receiving federal financial assistance. Next, the Age Discrimination in Employment Act of 1967 protects certain applicants and employees 40 years of age or older from discrimination on the basis of age in hiring, promotion, discharge, compensation, or terms of employment. Let me now briefly provide 3 examples of U.S. government efforts coming out of our Department of Health and Human Services Administration for Community Living. First, its national assistance legal programs provide access to the justice system through civil legal counsel and representation to older persons with the greatest economic or social need in order to preserve their independence, choice, and financial security. Secondly, ACL's National Center on Law and Elder Rights is a national resource center focused on ensuring justice for and promoting the rights of older adults through training, case consultation, and also advocacy for access to benefits, affordable health care, guarding against discrimination, and combating poverty and hopelessness. In addition, HHS provides counseling and assistance in accessing pension benefits and financial literacy education. Thirdly, the United States supports the development of systems and programs to protect older adults, to prevent abuse from occurring, to protect people from abusive situations, and also to support people who have experienced abuse to help them recover. HHS manages the Elder Justice Coordinating Council, which coordinates agencies and activities across the U.S. government related to elder justice. These activities would include preventing, detecting, and prosecuting elder abuse, neglect, and exploitation. My question is to the panelists are, have you seen best practices to help older persons become more adept at using technology? This has been a problem that some of the panelists alluded to before, and it's especially important to access assistance during this period of COVID-19. Thank you very much, Madam Chair. Thank you.
Thank you very much. We now move on to, we'll collect that question and we move on to Help Age International. Bridget, you have the floor.
Thank you, moderator. Help Age International would like to thank the panelists for their presentations and the Secretariat for the working document. The number of older people seeking and failing to get justice should not be underestimated. The working document refers to the consultation Help Age carried out with older people before the pandemic. In it, 71% of participants said they had a justice problem they wanted solved. And of those, over half, 53%, had not found a solution. Given restrictions on justice systems generally, and the discriminatory age-based restrictions many older people have been subjected to during the pandemic, this justice gap is likely to have increased. The working document also states that it's important to ensure that access to judicial and non-judicial proceedings and their outcomes are not influenced by ageist stereotypes. It's evident from the experiences of the older people in our consultation that negative ageist stereotypes are indeed systemic and are affecting both proceedings and outcomes. An older man in Rwanda said, the insurance company refused to pay because, according to them, my lawyer was asking too much for a very old person. And he went on to say, I'm still waiting for the judgment. I believe they have spun out the procedure for 2 years, hoping that I could die before it's resolved. The working document recognizes that none of the international human rights instruments and treaty bodies have specifically addressed the barriers facing older persons in accessing justice. If we are to age with rights, we cannot allow this gap to continue. HelpAge supports the joint statement by national human rights institutions and civil society organizations and the statement by the Global Alliance for the Rights of Older People, both of which call for the immediate drafting of a new convention to address this gap. I'd like to finish with a question for Mr. Mitchell. How will articulating the right to access to justice in older age in a new convention help address the ageism within judicial and non-judicial proceedings? Thank you very much.
Thank you very much, Bridget. Let's move on to the next speaker, and then we'll break for the panelists to answer the questions. I now call on the representative of Mexico. Ma'am, you have the floor.
Otra vez yo, ¿cómo están?
It's me again. How are you? Moderator Carmen Gomez, thank you very much. I would like to start by once again stressing access to justice in Article 31 of the Convention, which is the most pioneering thing we have in the region. We are pioneering in this, and it's very valuable to be able to use it as a guide, as Alejandro Rubino was saying. I wanted to just underscore the importance of that regional instrument which we have. In many of our countries, we do use it as a guide for our work. In Mexico, we have been working for many years on providing advice, legal advice to older persons, and particularly doing this free of charge, making it accessible and universal. And it's very important that people know their rights. We're making sure that they know about their rights and that they have access to it. It's very important. They need to know what institutions are defending and protecting them. That is one of the major parts of work ahead of us as well. I also wanted to mention that the pandemic made these services inaccessible again because many were closed because of fears of contagion. Infection. People couldn't access these services, and often they happened on the internet or on the phone, but that was not sufficiently useful for them. Recently, we've been receiving a lot of calls from in our National Institute from older people. We have been addressing many of their doubts and questions and referring to other institutions as well. I also wanted to recall something that Karen Gomez was saying, something I really liked, which talked about fragmented responses. That is a real problem. Because across the world, various institutions, organizations are providing services, but they're not really communicating amongst themselves very often, which would make the work properly coordinated. From INAPAM, from our institution, we will be disseminating an interinstitutional protocol for a life free of violence against older persons, with the aim of establishing interinstitutional multidisciplinary actions to prevent, diagnose and detect violence against older persons so that they receive the necessary care of all possible kinds and scopes. They need to have guarantees of protection and institutional recovery of their human rights, as well as all tools available to them which allow them to be true rights holders and to improve their quality of lives with security and integrity. A huge job, and once again I want to recall what some of the panelists said, including Alejandro Rubino, training and capacity building amongst people who are providing access to justice for older people and justice for older people. There are very complex issues at play often, and it needs to be ensured that older persons are not underestimated, as they often are. And I repeat something that others have said as well, which is about gerontologizing public services, as it were. We need to identify all public service providers and ensure that they are aware of the issue of aging and older age. Thank you very much, Ambassador. Thank you very much, Moderator, and all the panelists. Thank you very much, Karen Gomez.
Yeah, Senora.
Thank you.
Now we move on to, perhaps I can take the representative of Argentina to take the floor before we answer the questions. Sir?
Hola, buenas tardes, ¿se escucha?
Can you hear me? Moderator, can you hear me?
¿Ahora se escucha? ¿Sí?
Thank you very much, Moderator. Thank you very much, Chair. Unfortunately, the interpretation will be suspended because of quality of sound.
En un tema de absoluta relevancia para las personas mayores.
Sir, I'm sorry, but the volume is not enough for our interpreters to be able to interpret what you're saying. Can we move back to you afterwards? Perhaps we can solve your audio problems. Just proceed to the panelists answering the questions. So we'll get back to you, sir. Thank you. So we move on to perhaps the panelists asking the question about the digital divide, best practice in taking a look at using technology for older persons. Anyone can answer that. And then the earlier question about a government working with civil society as well. And then we proceed to Bill answering the question about access to justice articulation in the convention. So can I ask perhaps Professor Kedja, would you like to answer the questions?
Hello. Well, thank you very much. This is a fundamental question, but also a very broad issue. I think that also during this period of the pandemic, it was visible that the communication has been transferred largely to internet. But it is not only the question during the pandemic, where in fact it was very difficult for example, for many people to call the hospitals in order to register themselves for the vaccination. The preferable method was the internet, computer, and the illiteracy in computer illiteracy is today even showing on this example a dramatic obstacle to benefit from rights and to have access to services. It's well, when we are talking, because the main topic today is the access to justice. When we are talking about access to justice, we always, sooner or later, are coming back to the question of legal aid. This is very similar to the communication now, to the new technologies in communication, to internet communication and so on. This is one point. I mean, generally the access to information, access to communication. But there is another point. The large parts of the administrative proceedings and also judicial proceedings gradually, perhaps they are not that advanced, but the administrative proceedings have been transferred to internet. Now, if somebody doesn't have a sufficient experience in this regard, is just excluded from the possibility to participate in the administrative proceedings, and in this sense also from the enjoyment of rights, from defending his or her rights. So when we are talking about some conventional regulation of the assistance to disabled people, conventional regulations of the assistance to of the legal assistance to persons, to older persons, then we should also talk about now the mechanism of the assistance in access to modern technologies as a continuing exercise, as a continuing service. Otherwise, I'm afraid that the technology, I would say, the internet exclusion can really be, well, not only detrimental, can be devastating to people's life. Thank you. And just to add one point, I think all these issues should be really taken very seriously into account and put really in the form of the legal obligations, legal entitlements in the discussed proposal of the convention. Thank you.
Thank you very much. Shall we proceed to, have we solved the problem of Senor Robino in terms of his audio? Can we have you to respond to the two questions? Can we move to Tony, Mr. Tony Ojuku, if we don't have Senor Robino? Yes. Tony. Civil society and government together. That's the question.
Yes, I want to apologize. I lost my network, and as I was trying to respond to the question. Now, exactly, government must work with civil society. In fact, it is part of the strategic plan of most national human rights institutions to work with civil society for the promotion and protection of the human rights of older persons. So I think the way forward for this is that the government and civil society should develop a consultative plan of action to mainstream human rights and access to justice for older persons in all legislations, in all institutional arrangements, in all government policies. And that should also be taken into consideration in drafting the international legislation.
Tony,
Yes.
I'm sorry, I have to interrupt you because your sound is really very weak and the interpreters are having a hard time.
Can you hear me better now?
Is that better?
Okay, let me use an earpiece then.
We'll get back to you, Tony.
Can you hear me better now? Can you hear me better now?
Tony,
Unfortunately, the sound quality is still insufficient.
good enough? I'm sorry, it's not good enough. We'll just get back to you. And maybe I can invite Senor Robino to take the floor. Okay, it's not working. So we go to the next speaker. We'd like to remind you of the time limit. We're actually running out of time. So I invite the International Federation on Aging. Madam, you have the floor. Perhaps you can ask the question right away so that we can revert to our panel. Thank you.
Thank you very much. The International Federation on Aging appreciates the opportunity to provide an oral statement in response to the question of access to justice. Now, throughout the COVID-19 pandemic, but also well before, older people have been relegated to positions of inferiority and vulnerability based on chronic age. And this is the pervasive form of discrimination and infringement on human rights we know as ageism. Studies showed that before the pandemic, 55 to 70% of older adults reported feeling marginalized, and this has likely increased significantly. This deprived older adults of their agency, autonomy, and independence with decision-making. Having the agency to advocate for one's human rights through access to justice and legal frameworks is now paramount, considering the disproportionately severe impact of pandemic measures leading to greater incidences of violence against older persons, physical, emotional, financial, and sexual abuses, and mental health challenges exacerbated by isolation and psychosocial traumas. However, there are currently no existing provisions to guarantee access to justice to the over 1 billion older people aged 60 years or more in the world today. The appalling and shameful mortality statistics within residential facilities show failures of policy and practice in ensuring fundamental human rights to life and health, and also to dignity in death. Prohibitive visitation policies within residential facilities impacted the fundamental right of every human being to make decisions by restricting access to legal services regarding supported decision-making, advanced care planning with family members and caregivers, and the determination of capacity. Autonomy, dignity, and justice in later life require formal acknowledgement through a legally binding instrument to ensure the ability of older persons to make personal life decisions, healthcare decisions, financial and property decisions. Within the context of the United Nations Decade of Healthy Aging, the International Federation on Aging is honored to have the opportunity to work alongside member states to advocate for the rights of older people towards tackling the pervasive discrimination and stigmatization of ageism. And the rights of older people, as we know it all here today, are human rights which must be respected and protected. Thank you.
Thank you very much. I'd like to call on the representative of El Salvador. Madam, you have the floor.
Muchas gracias.
Thank you very much, Madam Chair and Madam Moderator. As the panelists were saying, the COVID-19 pandemic has shed light on the limitations in guaranteeing the rights of older persons. We have borne witness to various issues around the rights to mobility, timely medical care, access to information, which reflect not only age discrimination but also differentiated treatment with various intersectionalities such as gender, disability, rurality, ethnic groups, inter alia. In El Salvador, There is a framework in force and legislation, but this does not correspond to reality and with the focus of tackling active and healthy aging. Thanks to international instruments such as the Inter-American Convention and the active role of civil society, we have defined a new normative framework which corresponds more to this vision of guaranteeing rights. This new normative framework will certainly lead to changes in favour of older persons in our country. The challenge is strengthening the mechanisms for access and effective administration of justice for older people. We therefore believe it's important to bolster the importance of developing the legally binding international instrument which will guide countries in taking measures and will guarantee the rights of older persons, above all in contexts of emergencies such as the one we are living through at the moment. Thank you very much.
Thank you very much. I now move on to the representative of Bangladesh. Sir, you have the floor.
Thanks to Chair, Madam Chair, and thanks to moderators. On behalf of Bangladesh, I'm presenting the situation of Bangladesh in terms of older people's access to justice. In Bangladesh, legal protection of older people is very low because there is no specific law to addressing the legal support of the older peoples. But there is a legal aid in Bangladesh for the underprivileged group, but older peoples cannot, in most cases, cannot take advantage or cannot get access to this legal aid because of their mobility, limited mobility, and also the family feels no support for the such access to the legal or others measures. And in many cases, older people deprived of legal aid. Older people also have been needs because in old days, older people losing the control over their property, and so they cannot use their property to the well-being of their health and other issues. In many cases, older people face misconduct of the care provider or in public places, and because low level of legal protection, they cannot get any addresses of this sort of misconduct. Older women are highly, in Bangladesh, older women are highly legal protection because they have less control over their property. They have limited mobility, so they cannot get any justice from the uh, criminal court or others dispute resolutions mechanism. So there is two things. One is a low demand because older people feels if they proceed to get justice, then they, in case of family abuse and others problem, they most cases they don't go to the court and want to get a justice. So demand side, older people's also low demand and low access to the justice systems. And other side, the constitution in Bangladesh has give the very legal protection, but it is generic. So many way older people are deprived of the access to justice, and international organization and human right organization who have a strong legal aid, they also not sensitive to the older people's special situation of abuse, because older people are silent because they are not reported their deprivation or legal deprivation or access to the to connect with the human rights organization who have give the legal support. And finally, the international finally both the absence of human right instrument at national level, also international level, they are highly protectionless, and they have almost zero access to the justice. And recently, the older people, there is a breakup of family, and older people's less control over the land and other property. The demand is increasing to legal aid and others legal measures, but in absence of older people specific legal support, they are not getting any legal protections. And Bangladesh has also a law which is not very effective, because this law is only covered when they are deprived of support from the family, but others way older people's abuse and deprivation are not addressed by the law. So in one side, older people need new law, and other side they also need the support of capacity building so that they can get connected with legal aid. Especially in COVID situation, older people became more vulnerable, and they are left by their family, and they are without any medical access. But because they have no legal measure to protect themselves, so they face the humanitarian crisis, and Bangladesh legal aid and other human rights group did not come to support them. So we have to struggle in two ways. First, we have to establish national mechanism to protect, to advocate older people access to justice, and we also need to international instrument like older people human rights convention, which is provide the legal instrument by ratification. National government also became more protective for the older people, and they gave the protections. So we supported supported the convention, and convention give the new way which will give older people's legal protection in Bangladesh.
Thank you very
Thanks,
much,
Joan.
sir. Thank you. We now proceed to, before we proceed to the next speaker, I'd like to ask permission from the chair if we could extend 10 minutes. Is that okay, Madam Chair?
¿Le parece bien, señora presidenta? Sí, estoy de acuerdo.
Yes, I agree. In particular, because we have three people, all of whom have the right to speak. So let us split up these 10 minutes between the three people left, please. Thank you very much for your coordination.
Thank you very much, Madam Chair. And now I call on the National Human Rights Institute of Croatia. Ma'am, You have the floor. May I request perhaps to keep on time? Thank you.
Madam Chair, Excellencies, delegates, ladies and gentlemen, it's an honor to take part in the 11th session of the Open-Ended Working Group on Aging. In order to fight physical, psychological, financial, and other types of abuse perpetrated against older persons, they, as rights holders, need to have unhindered, age-appropriate access to justice. For older persons in Croatia who live in rural and remote areas, reaching the court and protecting one's rights can be difficult. The judicial reforms of the last decade made courts less accessible. Many of them closed their outposts and moved the judges to bigger cities, which made legal proceedings a costly and time-consuming venture. Furthermore, national statistics show that 1 in 2 persons who are over 65 and live alone are at risk of poverty and cannot afford court fees and expensive legal services. Many rely on the free legal aid system, which is struggling because of delayed government funding, so much so that in some, especially remote parts of Croatia, the free legal aid providers have to scale back or shut down their operation. As a result, many older persons cannot reach free legal aid or afford professional legal services, which curtails their access to justice. Even with legal aid, accessing justice requires age-appropriate procedures. In maintenance until death cases, vulnerable plaintiffs are left without property or adequate care and face desperate, unsafe conditions during lengthy proceedings. The Ombudswoman heard from a 91-year-old plaintiff who was waiting for an appeal court ruling for over a year. Despite the evident risks surrounding maintenance until death contracts, the Ministry of Justice of Croatia did not implement the recommendation of the Ombudswoman to expedite all such proceedings and collect data on their duration and the number of plaintiffs that died before rulings were issued. With a backlog of cases and lack of sensitivity on the matter, older persons cannot rely on timely judicial protection. In the Council of Europe framework, the European Court of Human Rights finds the advanced age of a person relevant in considering whether a case is heard within a reasonable time. In those cases, the court established that the administrative and judicial authorities are obliged to act with exceptional diligence in the light of the applicant's age and state of health. On an international level, Croatia joined the CRPD in 2007, and Article 13 of the CRPD explicitly mentions effective access to justice for persons with disabilities on an equal basis with others, including through the provision of procedural and age-appropriate accommodations. However, in Croatia, the CRPD is rarely interpreted or implemented with older persons in mind. Therefore, due to national policies that fail to protect the rights of older persons and a fragmented, inadequate international framework, we show our support for a comprehensive international instrument that will address the rights of older persons and guarantee access to justice in an affordable and timely manner. Thank you.
Thank you very much. I'd like to call on our independent expert, Claudia. Please take the floor.
Thank you for giving me the floor. It's an honor for me to be with you today, and also I would like to thank the panelists for their contributions. As we all heard, that access to justice is one of the main provisions to ensure and enjoy all the other human rights. I want to raise awareness that we had these meaningful discussions with my colleague, the Special Rapporteur on Disabilities, and you can still have a chance to see the conversation on web TV. And we came across a couple of obligations and obstacles which need to be addressed if we have a new article on the rights to access to justice. Therefore, I would like to ask the panelists, from your perspective, what are the main 3 barriers we need to overcome to ensure access to justice for older persons? Thank you so much.
Thank you very much, Claudia. I'd like to give the floor to the panelists. Perhaps we can start with Tony, and then Bill, Senor Robino, and Professor Kedzia. Perhaps we can have your responses to the questions, and please keep your responses down to 2 minutes each, strictly, please. Thank you.
Thank you very much, the moderator. The first question was how CSOs can work with government to deal with the issue of access to justice for older persons. I think CSOs can work with government in terms of awareness creation, in terms of advocacy, in terms of sensitization on the rights of older persons. Most of the older persons don't even know how to access their right to justice. So awareness for them in this area can help them to know how to access justice.
Tony,
yes.
Tony, I'm sorry. The audio is still a problem. I would move to perhaps Mr. Robino, Senor Robino. We'll get back to you. We'll try to get back to you.
Hola.
Hello? Can you hear me now? I think the problem's been resolved, hasn't it? Yes, thank you. Well, there are broad questions. I want to talk a little bit about the question of obstacles and barriers, and also what previous speakers have been saying. I think this issue of barriers and obstacles to access to justice is fundamental, particularly in developing countries. When I made my statement, I went over that part quite quickly, but it is true that older persons have many obstacles in accessing justice. But in developing countries, there is social and economic marginalization of older persons. In my country, for example, there are huge geographical areas between, and having access to courts for that reason is very difficult. There's also a lack of accessibility to judicial locations. And so this addition to with regard to development makes things even more complicated. And so challenges are faced by countries also because of delays in judicial proceedings. You know that there are countries who have systems which means that the resolution of cases can go quickly, but there may not be such systems in other countries, and everything is still done in written form, and things go much more slowly, and some people cannot wait. And this is an important point. Older persons cannot wait. Their situation is not the same as everybody else. So mechanisms which exist in somewhere like Costa Rica, for example, where various color codes for different cases or various different priorities for each case to make things go more quickly is fundamental. That's a starting point. This goes, I think, for obstacles to the legal and judicial proceedings in particular. Thank you.
Thank you very much. I'd like to give the floor to the last speaker on the list, and that's International Network for the Prevention of Elder Abuse. You have 2 minutes.
Buenas tardes. Muchas gracias por este espacio.
Good afternoon. Thank you very much for this space for dialogue. Access to justice is, has already been said, a fundamental right based upon the power that all human beings have to rationally require just solutions to their problems. This is why a central legal mechanism can ensure equality and non-discrimination, and ensure that people are listened to and that there are equitable responses. Access to justice is also a political tool, a key political tool, because it guarantees democratic well-being and respect for institutions in resolving disputes. Moreover, this is one of the cultural roots. At the beginning, this was set up as a mechanism to overcome blood revenge crimes or punishment, taking matters into one's own hands. Do you think that older people should be deprived of this basic right? Do you think that they have this right sufficiently at the moment? Do you believe that baby boomers have easy access to justice? And particularly during the pandemic, when they had a lack of health resources, older persons face the same needs and have the same needs of access to justice as any other human being. However, throughout the world at the moment, the political and legal systems means that they face a difficult and dangerous game of power in having this. Not everybody is being treated equally. An equal playing field is not provided. This social practice is based upon prejudices, does also lead to serious damages and jeopardizes people enjoying their rights. It leads also to generalized poverty, infantilization, abuse. It makes something that is impossible into reasonable, something reasonable almost. Older people do not have their rights, and amongst those older people, women in particular. The Office of the High Commissioner recognized in this session the fact that not sufficient attention was being paid to such issues and to the problem of access to justice. In INPEA, we deem it a priority to have a universal convention which places the rights of older people and their access to impartial justice, which is also expedited, with due diligence and preferential treatment as well for older people in the resolution of their disputes, as is done with the current Inter-American Convention on Human Rights for Older Persons in its Articles 3 and 31. It has had positive results so far, such as in the Flores case, where the Inter-American Court specifically ruled about the right of justice for Mr. Flores. And in the Leteviches case recently before then, Law 9148 in Argentina provided a declaration of the rights of older persons. Many years have gone by since then, and the population has aged as a whole. But the same problems are still persistent, as are seen by social practices and policies during the pandemic. The time of rights has come for these people. The time is now, and with this convention. Thank you.
I'm sorry we don't have time anymore, and I'd like to pass on the floor to our Madam Chair. Thank you very much. It's been an honor to be moderating. Thank you.
Gracias. Muchas gracias. Hemos llegado al tiempo.
Thank you. We have come to the end of the time we had available for this panel. I'd like to express my appreciation to our panelists for their statements and to the moderator and the participants for their views. Before adjourning this meeting, I should like to remind delegations that tomorrow morning at 10 o'clock, the working group will continue its interactive discussion under Agenda Item 7 on other matters and the way forward. To join tomorrow's meeting, please use the same link as you did this afternoon. The virtual meeting room will open at 9 a.m. The interactive panel discussion on access to justice of the open-ended working group on aging is now concluded. Thank you very much to all of you. The informal meeting is here.